Hello and welcome to Courts This Week on Live Law. I am Tanya Pandey and I bring to you judgments and orders being delivered by different courts across India every week. To stay updated, subscribe to Live Law and click the bell icon. We'll begin the episode with judgments from the Supreme Court and then cover other courts. The Supreme Court on 6th April recorded the agreement between Amazon and Future Group to approach the Singapore Arbitral Tribunal to resume the arbitration proceedings on an understanding that the tribunal will, on priority, hear Future Retail Limited's application seeking termination of the arbitration proceedings instituted by Amazon against the FRL's merger with Reliance Group. The court recorded that the arbitration tribunal will hear termination application filed by the Future Group under Section 32(2)(c) of the Arbitration and Conciliation Act 1996 in priority to other matters and pass orders. Based on the agreement by parties to appear before the arbitration tribunal, the bench, comprising of CJI N.V. Ramana, Justice Krishna Murari and Justice Hima Kohli, therefore disposed of the special leave petition filed by Amazon challenging the Delhi High Court's order which stayed the arbitration proceedings on a challenge made by Future Retail Limited. The Supreme Court on 8th April upheld the 2020 amendments made to the Foreign Contribution Regulation Act 2010, which introduced restrictions in the handling of foreign contributions by organizations in India. A bench of Justices A.M. Khanwilkar, Dinesh Maheshwari and C.T. Ravikumar pronounced the judgment in PILs challenging the Foreign Contribution Regulation Amendment Act 2020. However, the bench read down the condition that Aadhaar numbers should be given for FCRA clearance and said that applicants should be allowed to produce passports. The court also observed that it is open to a sovereign democratic nation to completely prohibit acceptance of foreign donation on the ground that it undermines the constitutional morality of the nation. In the judgment, the court compared foreign contribution to a gratifying intoxicant with medicinal properties if consumed moderately. The Supreme Court has held that if any land fell within the expression mine under Section 2H of the Coal Mines Nationalisation Act 1973, it would stand transferred to and vest in the central government under Section 3, subsection 1, irrespective of who owns the said land. The bench of Justices Hemant Gupta and V. Ramasubramanian noted that the residence of officers and staff of coal mines would also fall under the ambit of definition of mine. The Supreme Court on 8th April stayed the operation of the order of the Bombay High Court at Aurangabad, which permitted Anna Sahib Chudaman Patil Memorial Medical College to admit students to fill up its 100 seats in the MBBS course for the academic year 2021 to 2022. The court noted that Section 26(1)(f) of the National Medical Commission Act 2019 gives power to the National Medical Commission to issue directions for stoppage of medical admissions, and hence the view of the High Court that the Commission lacked such power was not correct. Considering the glaring deficiencies captured in a report pursuant to a surprise inspection conducted in January 2022, a bench of Justices D.Y. Chandrachud and Anirudh Bose directed the National Medical Commission (NMC) and the Medical Assessment and Rating Board (MARB) to carry out a fresh inspection within a period of 2 months to ascertain if the deficiencies continue to exist. The Supreme Court has held that consumer courts can grant relief to flat buyers who are aggrieved with the delay in delivery of the apartment as per the agreement. Consumer courts have the power to direct refund and compensation to a consumer for the deficiency in not delivering the apartment as per the terms of the agreement, the court held. A consumer can pray for refund of the money with interest and compensation, or could also ask for possession of the apartment with compensation, the bench of Justices U.U. Lalit, S. Ravindra Bhatt and P.S. Narasimha observed. The Supreme Court has observed that preventive detention cannot be ordered merely because a person is implicated in a criminal proceeding. In this case, an order of detention was passed against the detainee on 19th May 2021 under the provisions of Section 3(2) of the Telangana Prevention of Dangerous Activities Act. The order also noted 2 FIRs registered against the detainee. The order of detention was challenged before the High Court in a petition under Article 226 of the Constitution. The division bench of the High Court dismissed the petition. In appeal, the Supreme Court bench of Justices D.Y. Chandrachud and Suryakant quashed the detention orders and said that a mere apprehension of a breach of law and order is not sufficient to meet the standard of adversely affecting the maintenance of public order. Let us now go over important judgments from different high courts and other courts. The Bombay High Court on 6th April protected three broadcasters and entertainment companies, Asianet Star Communications Private Limited, Disney Broadcasting India Private Limited and Star India Private Limited against coercive action from the Competition Commission of India till the next date of hearing in June 2022. The bench of Justice Gautam Patel and Justice Madhav Jamdar said it was ordering no further action to maintain status quo until all the parties are heard fully before the summer vacation. The entertainment companies had approached the High Court against a February 28, 2022 order of the CCI that had ordered an investigation under Section 26(1) of the Competition Act 2002 by the Director General. The Allahabad High Court has observed that even a minor girl cannot be detained against her will or at the will of her father in a protective home. The bench of Justice Suresh Kumar Gupta directed the additional sessions judge or special judge POCSO Act, Sultanpur, who had sent a girl or alleged victim to a protective home, to call her from the Nari Niketan, ascertain her wishes and pass an appropriate order for her custody in accordance with law, keeping the wishes of the victim. The Madras High Court on 8th April directed the state government to organize a program spanning from 6 to 8 weeks, inviting one teacher from every school for sensitization on dealing with issues relating to children belonging to the LGBTQIA+ community. The bench of Justice Anand Venkatesh was hearing a petition filed by a lesbian couple who were being harassed by the parents and the police. When the matter came up for hearing, the court observed that there was no mechanism in the prevailing system for the children who belong to the community to discuss about their issues and make complaints in case they are being harassed or bullied. The Manipur High Court has clarified that the operation of Section 428 CRPC will be automatic unless the benefit is denied by the judgment. It further made it clear that even if the pre-conviction period of detention suffered, it is in the nature of simple imprisonment, it would still be liable to be set off against a sentence of rigorous imprisonment under the section. Notably, Section 428 provides for set-off of period of detention undergone by the accused against the sentence or imprisonment. NCLT Kolkata bench, comprising of judicial member Rajashekhar VK and technical member Balraj Joshi, while deciding interim applications in the matter of Ramsparoop Industries Limited, has held that just because the liquidation value is being projected higher than the value of resolution plan, the corporate debtor cannot be sent into liquidation for this reason alone. The object of the IBC is to put the corporate debtor back on its feet for the larger benefit of all the stakeholders, not just the creditors. That's all for today. I appreciate you joining us. I'm Tanya Pandey for Live Law and you're watching Courts This Week. Have a great day.
Subscribe to our channel and press the bell icon to never miss a video from Live Law.